My dear students, complaint under the Criminal Procedure Code. What is the difference between the complaint and police report? When that police report would amount to the complaint? These are the aspects which I am going to present very briefly. Complaint under Criminal Procedure Code. Section 2D defines complaint. Complaint means any allegation made orally or in writing to a magistrate. Allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offense but does not include a police report. This is a verbatim of section 2D defines a complaint. What is a complaint? Complaint means allegation made to the magistrate. Allegation made to the magistrate. Allegation made to the police officer is not a complaint. Allegation made to the magistrate is only a complaint. The allegation is to be made either orally or in writing. What is that allegation? That some person has committed an offense. That is very important. That some person has committed an offense. That person may be known or unknown. The person may be known or unknown. What is required is that some person has committed an offense. But this section 2D says, so what is it? Why we are making complaint to the magistrate? With a view to an action. That magistrate may take an action under the Cr.P.C. So complaint means allegation made to the magistrate either by orally or in writing that some person has committed an offense, that is the allegation, with a view to that the magistrate may take an action under the Cr.P.C. But the same section 2D says that it does not include police report. Complaint does not include police report, which means there is a difference between the complaint and police report. What is that? We'll see. Complainant is a person who makes formal complaint to the magistrate. Now, what are the essentials? It must be made to magistrate. Allegation must be made to the magistrate. This is very important. Allegation made to the police officer is not a complaint. Allegation must be made to the magistrate. It must contain an allegation. It must be made to the magistrate. Complaint is to be made to the magistrate. It must contain an allegation. What is allegation? That some person has committed an offense. Whether the person is known or unknown, it is irrelevant. That some person has committed an offense. So that the magistrate may take an action under the Cr.P.C. No particular form is necessary. There is no prescribed format. How to give the complaint? There is no prescribed format. It may be oral or in writing. Complaint can be given either in oral or in writing. What is required is that there must be some allegation. Allegation is most important. What the allegation discloses? The allegation disclosing that some person has committed an offense. So this allegation disclosing that some person has committed an offense. So it is the substance that is to be taken into consideration. Substance is important and not the form of complaint. How you have given form, what is there is any prescribed format or not, is not necessary. What is required is substance is very important. The substance is to be taken into consideration. The details of the offense, the name of the offense, the sections, they are not necessary. They need not be. Not even not he may not known also what is the offense that has been committed, under which section is the act that some person has committed an offense, which section, what is the nature of the offense, what is this. These are all not necessary. So a letter or a telegram addressed to the magistrate may also amount to a complaint. So it's very simple. Complaint can be given in any form, either through a letter or a telegram. A prayer to the magistrate to take an action may be express or implied. Now, who may file? So it is not necessary that complaint is to be made by a person injured or an aggrieved person or an affected person. Not necessary. So any person having knowledge of the commission of the offense can file a complaint. So complaint need not be given only by the person who injured or aggrieved or affected person. Not necessary. Any person having knowledge of the commission of the offense, they can file a complaint. There are, however, certain exceptions. In those exceptions only, aggrieved person or authorized by the court or by the statute can make a complaint. For example, if you take the offense of bigamy, suppose if the husband marries a second time during the existence of the first marriage, without giving the divorce to the first wife, he married the second person. The wife has to give a complaint. Only wife has to give a complaint. If the wife is a minor, guardians can give the blood relations can give a complaint. Similarly, if the wife marries a second time without giving a divorce to the husband only has to give a complaint to the court. So, except those cases where either the statute or the code says that the complaint is to be given only by the aggrieved person, then only aggrieved person is to be given. In the rest of the cases, any person can file a complaint. Not necessary a person injured or affected or aggrieved. There is one explanation under this section. What the explanation says, a report made by a police officer in a case which discloses after investigation the commission of a non-cognizable offence shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to be the complaint. So this is the explanation. What the explanation says, according to this explanation, the police officer investigate the case believing to be a cognizable case. Because there are two types of offences. One is cognizable and non-cognizable. In all cognizable cases, the police officer can investigate the case and arrest the person on his own without getting orders from the magistrate. Magistrate orders are not necessary. In cognizable cases, the police officer, he himself can start the investigation. He can arrest the person. So, in a particular case, the police officer investigate the case believing that case is a cognizable case. So, investigation has been completed. After investigation, it discloses that it is not a cognizable case, it is a non-cognizable case. Because in non-cognizable case, the police officer has no power to investigate the case. Unless and until he receives orders from the magistrate. After getting orders from the magistrate only, the police officer can investigate non-cognizable case. Then he can exercise all the powers whatever he had while exercising the cognizable cases. The same powers he can use and can investigate the case in non-cognizable case. But here he believed that case is a cognizable case. He started the investigation, but after the investigation, it discloses to be a non-cognizable case. Then he submitted the report to the magistrate. Then it is not a police report because without getting orders from the magistrate, he investigated the non-cognizable case. So it is not a police report, but it is only equal to complaint. It is only a complaint. It is not a police report because on the police report, the court will take the cognizance of the offence, but the complaint, it is only equal to the complaint, and the police officer in such a situation is only a complainant. What is the police report? Section 2R of the CRPC defined police report. A report forwarded by a police officer to a magistrate under subsection 2 of section 173. A report forwarded by a police officer. The police officer will forward a report to the magistrate under subsection 2 of section 173. That report is a police report. What section 173.2 says? As soon as investigation is completed, the officer in charge of the police station must submit a final report that is called a police report to the magistrate. The police report is forwarded to the magistrate who is empowered to take cognizance of an offence. So as soon as the investigation is completed, the police submit a final report. That final report is called a police report to the magistrate. And that report is to be forwarded only to the magistrate who is authorized to take cognizance of an offence. That is, who is authorized. After taking the cognizance of the offence, the magistrate will start the trial. Who is competent, who has a jurisdiction, to that magistrate, the police officer will submit the police report. So this section is applicable to both the investigating of cognizable cases as well as non-cognizable cases. So the officer in charge of the police station forward the police report to a magistrate in the form prescribed by the state government. The state government has prescribed a format. So the police officer has to submit the police report only in that particular format. So what the format includes? The names of the parties, the nature of the information, what is the information that he has received, the names of the persons who appear to be acquainted with the circumstances of the case, that is witnesses, who knows, who are acquainted with the facts and circumstances of the case, the names of those persons, whether any offence appears to have been committed and if so by whom. Suppose if any offence has been committed by any person, suppose if the offence has been committed, who has committed that offence, by whom that offence has been committed, whether the accused has been arrested or not, whether he has been released on the bond. Suppose if he released on his bond, whether he released with or without sureties, that should also be mentioned in it, whether he is released on his bond with sureties or without sureties, whether he has been forwarded in custody under section. These are all to be included. Now, what is the difference between the police report and complaint? In all cognizable offences, the police investigate the case without permission of the court. Permission is not necessary. Permission from the court is not necessary in cognizable cases. So, without permission from the court, he will investigate the case. At the end, submit a report to the court. That report is a police report. In all non-cognizable cases, the police has no power to investigate the case. The police officer has no power to arrest the persons. But when once he received orders from the magistrate, the police will investigate the case, complete the investigation, submit the report. That report is a police report. So, report submitted by police officer in cognizable case is a police report. Report submitted by the police officer in non-cognizable case, that is investigated the case after receiving orders from the magistrate, then after investigation has been completed, submit the report, that is a police report. But police officer submitted a report in non-cognizable case where he investigated the case without orders from the magistrate. Without getting orders from the magistrate, he investigated the non-cognizable case and submits the report. That report is not a police report. That report is not a police report. Similarly, explanation, what we have seen just before, explanation under this section. A report made by the police officer in a case which discloses after investigation the commission of a non-cognizable offence. So, thinking that it is a cognizable offence, he will investigate the case. After investigation is completed, it discloses that it is a non-cognizable offence. Then he will submit the report. That report is not a police report. So, when the report is not a police report, it amounts to complaint. And the police officer in that situation is not an officer, he is only a complainant. He is only a complainant. What is the difference between the complaint and FIR? Complaint is defined under section 2D Cr.P.C. First information report is not defined under the Cr.P.C. but it explained under section 154 Cr.P.C. Section 154 explains what is a first information report. But section 2D clearly gave the definition of complaint. The second difference, the allegations are made to a magistrate, but the first information report is given to the police officer. Third, Complaint may relate to cognizable or non-cognizable offence. You can give a complaint to the magistrate either with respect to the cognizable offence or non-cognizable offence. But here, first information report must be given to the police officer only in relate to the cognizable offences on the face of it. Only cognizable offences cases only FIR has to be recorded by the police officer because he has the powers to investigate the case. But in non-cognizable cases, he has no power. So FIR will not be recorded. A magistrate takes a cognizance on a complaint. Police officer starts investigation on first information. So this is the complaint. Complaint is the one where an allegation made to the magistrate either orally or in writing that some person has committed an offence and that person may be known or unknown with a view that that magistrate may take an action under the Cr.P.C. So police report, investigation completed in the cognizable cases, submitted a report, that report is a police report. In non-cognizable cases, after getting order from the magistrate, the police investigate the case and submit the report, that it is a police report. But in non-cognizable cases, without getting orders from the magistrate, if the police officer investigated the case and submits the report, it is not a police report. Similarly, where the police officer believes that offence, that is a cognizable offence, he will investigate the case, and after the investigation, it discloses that that offence is not a cognizable offence, that offence is a non-cognizable offence. Then also that report submitted by the police officer is not a police report. In these situations, when it is not a police report, it is equivalent to complaint. And the police officer in such situation is only a complainant. So this is the brief differences between the complaint, police report and FIR.